So this is the issue. Empirically validated, not just by myself, but gazillions of studies now in Canada and in the US. Nobody in their right mind ever argues with this any longer because there is so much qualitative and quantitative data to support it. However, it is something which is obviously not good news for those whose livelihood rests on providing legal services at the current rates and in the present structures in which those are provided. This is something else that is empirically validated. We know this to be true in almost every family court in anything like a semi-urban or urban area now in any part of North America. More than half the people there are coming to court without a lawyer. I mean, the numbers are just absolutely staggering, and they have gone through the ceiling in the last 10 years or so. And here's the problem. Those people are a darn nuisance. And so in this particular example of dealing with professional defensiveness, I was dealing with both giving the bad news, which was, you know, it's impossible to negate these as empirical facts, but it feeds into an attitude that is very prevalent, I think, among some parts of the practicing bar, that this is thwarting them from doing the great job that they would like to be doing for people, and in particular that people who come to court without lawyers are doing so to create chaos, because they woke up this morning and thought, oh, I feel like being Perry Mason, let me at it, rather than they don't have the money to afford to pay for a lawyer. So I have found myself, and still find myself, constantly, and this is ongoing. I'm looking forward to a little break this summer, but I basically spend a huge amount of my life now talking to bar associations about these messages. And although some people are very open to hearing them, some people are very upset about hearing them. And some of those experiences, and I have to say, as a female, perhaps particularly, they are some pretty bruising encounters that I have. So the thing that we didn't talk about when we did the panel last year, intentionally, was some of the really deep dirt that is out there in my own study and others about criticisms of the profession. So having spared everybody that last time, and getting the blowback that we did, I figured, hey, let's just go for it this time. So here is some of what people say. And of course, you know, again, just trying to go back to the loving critique, I have spent 30 years of my life training lawyers, working with lawyers. I have many, many incredibly respected and dedicated people who work in this profession who I know and love. But these are the consistent complaints that we hear in the data from people who have used lawyers and now have run out of money. More than 50% of my sample ran out of money to continue to pay them. So this is what they say. Counsel wasn't doing anything. Now, you know, it's not that I'm trying to say to you this is objective reality. We know it's not objective reality, but it is their perception, and it is extraordinarily deep-rooted. So the very best case is we're not doing a good job of telling them what it is we are doing, because this is what people, intelligent people, think very consistently. This will not surprise this particular audience. Counsel was not interested in settling. The two lawyers were just saber-rattling, seeing who could piss the other off the most, is a typical quote in this respect, and simply not enough effort being put into trying to resolve the case. There is a great deal of very upsetting data in my very large qualitative sample of SRLs, half of whom did begin with counsel, that they complained that their legal counsel didn't listen to them, didn't explain their decisions to them. Now, I'm sure, again, that all these lawyers thought that they were doing that, or they felt that they were doing a much more efficient job by making a decision to go in a direction that would be maybe more in this client's interest, in their opinion. But there was such a huge disconnect between what people felt was being done for them in their own best interest and what I imagined their lawyers thought that they were doing for them that was in their best interest. And finally, you know, consumers today, as I began by saying at the beginning, are an awful lot more savvy and an awful lot less deferential than they were in my parents' generation. And there are many people who point out that perhaps completing a form isn't something that they should be paying $350 an hour for, given that they actually know that it's the secretary who does that anyway. So, there are a few little kind of cracks here in terms of just what is the value of the work. So these were the consistent complaints. And I never show this slide normally. This has been buried, right? This doesn't come out very often. But even without showing this, as I say, there is a lot of upset at thinking about these critiques. So here is my response that I hear pretty consistently also. But you are just lawyer bashing is by far the most common response. And the thing that I find very interesting about this, and one of the reasons that the three of us got interested in thinking about presenting this topic to you here, is that the expression lawyer bashing is used as a kind of toxic shutdown in much the same way that accusations of racism, sexism, homophobia are used in a way to stop the conversation. Once you're accused of certain things in our culture, you zip it, right? Even if it's unjust, you just know, I better not go any further here, because that is a really toxic accusation. And in the legal profession, lawyer bashing is a toxic accusation. It doesn't necessarily mean that it happened. It doesn't necessarily mean it was the intention, but it is a word that's used to stop the discussion. And I hear it all the time. Even when I think, God, I've been really kind here, I still hear that word all the time. You are betraying the profession, a little bit like Bernie said he had in some of his responses. I've had lots of people say that, this is disloyal. And then these three words on the bottom are the words that appeared in the small proportion, but nonetheless a small proportion of evaluations that we got to last year's session that were negative. And these were three of the most common words that we used. It was insulting, what we spoke about last year. It was boring. I mean, that's the one that offends me the most. Like, how can this stuff be boring? I mean, you may hate it, but how is it boring? But you'd be surprised. There were 3 or 4 evals that said that what we did last year was boring. In fact, one said, all this call to arms is boring. But, that's what it said, and disrespectful. So these are some of the themes in terms of the response. Now, just like you're going to find with Andy, and just like with Bernie, this is the part that I have struggled the hardest with, and we have all done our very best, and we're going to throw it to you, of course, when we're done talking, to figure out what the lessons learned are here and what we can do to bring important but difficult messages to people in a way that they will hear them, because everybody in this room knows there's absolutely no point talking if people aren't listening. So we have to figure out how to get them to listen. Obviously, significant change means there's a great deal of uncertainty and insecurity in the legal profession. Obviously, I'm not sure what we do about that, but that is part of the context that has to be recognized in order to figure out how to handle this. The second point on this list, originally I'd written, don't shoot the messenger. And Andy pointed out that this sounded self-pitying, to which I pointed out, I feel sorry for myself sometimes doing this. However, it's a slightly better framed here, perhaps. The bearer of the bad news may take the brunt of the negative reaction. Now, maybe that is just part of the territory, which is, I think, kind of Andy's point to me. But this is hard. It really is hard. I mean, at this moment, I'm kind of a little tired out with this. So I think we need to factor into how we think about managing, responding, evaluating criticism, what it does to the people who are the people bringing the bad news. There are clearly strong vested interests in protecting the status quo. One of the things that I have been really very surprised about is the extent to which people who would accept without too much difficulty the premises that I put up here earlier, but are still very, very resistant to doing anything different about them. I mean, this was the implementation gap that Justice Cromwell was talking about. I think it's one of the real challenges that we face here, that we can all sit around and go, woe is me, no one can afford lawyers, and then? we need to do something. And how do we do that when, in fact, the way the profession is structured at the moment, and this includes all of the people in the profession, the people doing wonderful work as well, it is structured in a way that protects those vested interests and the status quo. So what do we do about that, and how do we let any kind of incursions in, perhaps represented by members of the public and their views? And finally, people find it hard to hear the positive at the same time as listening to what needs to change. I did a talk just in the last month to my local bar association, which of course I should have realized. I mean, Sue and I have this joke about the places I go where I need protective clothing for the rotten fruit and that kind of thing. I didn't expect that today. I needed that today. But this was one of those protective clothing gigs, as we call them. This was my local bar association, which in some ways is always the hardest place to speak, is in your local bar. So I thought, I know what I'll do. I'll go in and I'll make them so proud of us because we're doing this project that gets all this national publicity, and everybody working on the project is from Windsor and Essex County, and they will be so proud when they hear this. So I do all this stuff about, la, 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 all these news items, la, la, la. And then I get to yes, but I'm afraid people can't afford you. And that's it. Like, it's game over. So I realized that people really can't hear the positive part if they're also being asked to hear something negative at the same time. And again, this is a lesson that I think we know from our own practice in conflict. Okay, Andy.
I thought I was giving the legal profession a present. Okay. For those of you who don't know what collaborative law is, it's limited purpose representation. You'd call it unbundling in Woody Wosten language. You represent somebody only for the purposes of settlement. No, and if you don't settle, both lawyers must disqualify themselves. Either party can terminate at any time for any reason or no reason, and it's entirely voluntary. You have to sign a contract called a participation agreement where both parties agree to it. It grew as a grassroots movement in the United States and in Canada. And Julie did some of the most fundamental early research on it, basically by divorce lawyers who rejected the view that they were adversaries. They wanted to problem solve more. And it almost is exclusively being used in the divorce context. While there have been attempts to extend it to other areas, it didn't work. So I was asked by the Uniform Law Commission, which is one of the two most prestigious law reform groups in the United States, that drafts model statutes for state representation, to be the reporter for the Uniform Collaborative Law Act. And this is a very transparent process that's done. It took 3 years. It was debated by a Congress of Representatives from all the states twice, read line by line. Okay. What you have to understand about this is the Uniform Law Commission, which drafts the Uniform Commercial Code, the Uniform Marriage and Divorce Act, every uniform act that's in every law school casebook. It's one of the most fundamental entities. They did it to support collaborative law, which was being practiced by a significant group of divorce lawyers, mostly, in collaboration with interdisciplinary professionals. Why were they doing that? Why was collaborative law important enough for the Uniform Law Commission to take notice and ask for the drafting of the act? It's all the stuff Julie was just talking about, except it was the increasing expense and emotional cost of divorce litigation. And it was pretty clear from the data that some percentage of divorce clients do not want to fight. They want planning and settlement options, and there's some conflict along the way that they need to resolve, but they want to get past this and move on with their lives. The second thing is the data is absolutely dead bang clear that the more the parents fight with each other, the more their children go into the tank. I mean, that's like not debatable. There are many things about it that's debatable, but if they're yelling and screaming and fighting with each other, and that's encouraged by lawyers, that they get worse and not better. So if you have responsibly managed conflict, moving towards problem-solving solutions, you're going to get, you're more likely to get a better outcome for your children. Increasingly, as Julie just emphasized, in a different, in sort of self-represented litigants, the data is pretty clear that the perception of the profession is going downhill. Lawyers are regarded as conflict promoters rather than conflict resolvers in general terms. Now, that doesn't necessarily apply to your own particular lawyer, and it doesn't apply to every lawyer, but that's a major problem that's been going on with the legal profession, and it's pretty clear over and over again. People describe lawyers as getting in the briar patch with lawyers. They get scratched and they can't get out of it. So collaborative law seemed like a good idea, right? And it seemed like an idea that would catch the trends that Julie was talking about, and we could do something about it. So we drafted a statute through this process I was talking about. It was designed to set minimum standards for the participation agreement, informed consent by the clients. It included screening for domestic violence and informed consent. And above all, it created an evidentiary privilege for collaborative law communications. It's a technical evidence problem, but if the husband and the wife are perceived of as adversaries, what they say to each other in settlement negotiations in some circumstances can be discoverable and admitted in court. We tried to eliminate that so you could put a shield of confidentiality over the evidentiary privilege. Okay, the Uniform Law, we held meetings. We discussed this with everybody. It was open, transparent, every lawyer group you could get your hands on. The Uniform Law Commission has a long-standing deal with the American Bar Association. The American Bar Association is the largest voluntary association of lawyers, I think, in the world. 40,000 members. I don't have the exact number. And the deal is that the Uniform Law Commission drafts a statute. It goes to the ABA for approval. If it's approved, they go jointly to the states to have the states enact them. Now, obviously, it's much more perception is much more powerful if the Law Commission and the lawyers groups say together, this is good legislation, draft it. Okay? Now, what I didn't understand was how deeply embedded in the ABA the litigation section was, and how deep a threat they perceived the Uniform Collaborative Law Act to be. I did not understand that. Okay, I understood it the day I got to the House of Delegates before the ABA, and the head of the ABA litigation section called me incompetent, which was great. I go, what do you mean? I'm not competent. I know what I'm doing. I just drafted the statute that went through all these people. I'm a law professor. Okay, couldn't know it because I didn't know what it was doing. And all right. But the main things that they were saying is it was inconsistent with a lawyer's duty to represent clients zealously. Okay. Lawyers also have a duty to problem solve and advise their clients and to present argument and to present rational alternatives. There are famous quotes from minor lawyers like Gandhi and Lincoln about encouraging settlement and how it was a rational settlement and how it's a major portion of a lawyer's duty. I got hit over and over again with, you're ruining the legal system. You're not representing your client zealously. Mostly from people who never practiced divorce law and don't understand that if you run out of money, you can't litigate anymore. Okay? Then they said it might be used as a strategic tool to disqualify counsel. Sure, absolutely, but it's a tool for both sides, and they both voluntarily agree to it. Then there was this is what I love, the regulation by statute threatened the independence of the bar. I was going, you're going to pass the statute and we're shackling lawyers? No, we're giving them more options to practice. We're giving them more ways that they could actually represent people and do things and legitimizing a problem-solving process. And, by the way, if you ever look at the statute books, there's bazillion statutes that regulate the behaviors of lawyers in court and out of court. But this was a bad one because it was inconsistent with the lawyer's design. Okay. Now, I never said this, okay? But it was an undercurrent of the duty. Julie talked about strong interests. There was a fear that the economic interests of lawyers were being hurt by collaborative law settlers because they didn't make money from litigation. Now, in response to that, it's very difficult to deal with fears that aren't articulated well, but it would come out in various ways and points. A lot of matrimonial fees are never collected because people are unhappy for all of the reasons they were talking about. The profession gets a bad reputation for spending money that it shouldn't be getting. Okay, it's not at all clear to me that you're going to lose fees if more cases are problem solved and settled and you have clients who are happier and give you a good recommendation. However, this was there. Okay, so here's what happened. The first time in a history, in a 70 or 80-year history, the ABA did not endorse the Uniform Law Commission's recommendation. It had substantial support from many leaders in the legal community, but the litigation section overwhelmed it. What has happened? Okay, this is great. The ABA is a voluntary association and is losing members. It just lost 4,000 more because it would not accommodate the collaborative lawyers. It didn't believe in them. It sent them a message that we don't believe in you. Honestly, from my perspective, it put the ABA on the wrong side of history. It basically said, here we stand, and we stand no further. We will move no further. Okay. Now, these are the same folks who are expanding the reach of transnational law, allowing lawyers to invest, non-lawyers to invest in legal proceedings, but they're not going to let somebody collaborate for a settlement. They're not going to endorse that. The result has also been that the legislatures, and this is, I guess, I don't know if it's good news or bad news. I can't kind of figure that out. The statute has been enacted in 10 states in 3 years, which for a uniform act is actually quite extraordinary progress. It usually takes 20 years to get 10 states to enact a uniform act. So what have I learned? I should have anticipated their opposition. Most of them do not practice family law and did not understand it. And I kept wondering during the course of this debate if I had only arranged meetings between the litigators and the collaborative lawyers, maybe they could talk it out. Maybe. I'm seeing head shaking. Yeah, I kind of came to that conclusion too. But it sounds nice, doesn't it? I kind of kick myself because I make my life trying to teach law students that there is a responsible way to be a lawyer. And yes, at times you have to litigate, but that's in family law. Last resort, try problem solving first, try collaborative law, try everything else first. I certainly didn't like the personal abuse, but after a period of time that was water off your back. What I was really distressed by was how much the litigators liked the sound of their own voices. They kept making the same sort of what I would in New York call BS arguments over and over and over, and they said the same thing. And there was no way to penetrate it. There was no way sort of around that.
General comments, questions, responses to anything we've said. Yes. I think there are a lot of environmental and systemic things. And I think in many ways we are, I'll speak about the conflict intervention field, which is what I now call it. We are both a profession and a movement in some ways. We are also, and I think this is true of all professions, by the way, we are also both about social change and social control. And those are tensions that play out all the time. What some of this stuff is saying is, let's be a little bit more movement than about social change. And we're running against some of the forces that are saying, yes, but we're also a profession and we also have to exist to make the present system work. So yes, there are all sorts of other external factors. The aging of the graying of the field, the breakdown in all sorts of traditional dispute resolution mechanisms in communities and societies. There's a lot of other things that are totally not under our control. On the other hand, it still poses the same challenges for us.
In the work that I've done over the last 15 or 20 years or so with lawyers, what's been very interesting is that age has not generally been an important variable in predicting whether or not somebody embraced change or not. And, we saw that, for example, with the collaborative law movement, that, in fact, a lot of the people who were moving into that area were people who had been at this 15 and 20 years, and they'd gotten so burned out with the adversarial model, that was why they were moving over there. I saw the same thing in my studies of mandatory mediation. Again, it wasn't necessarily the newbies. I think we have this kind of, I wish it were true, this idea that everybody coming out of law school is all turned onto this stuff. Not true. I think you see just the same kind of cultural conservatism there as you do with the older group. The only thing I would say is that in the self-rep study, what I have seen is a far more pragmatic approach amongst younger lawyers when it comes to earning money. And that's because they are carrying $100,000 of student debt when they graduate law school, and they darn well have to find some clients one way or another. So I think in that respect, age is important, but I don't think it's just about, I wish it were just about age and we could just shoot everybody over 60, but I just don't think it is.
Please.
66? It's interesting. Your question's great. My experience with the collaborative law people was older and younger, and the middle were the people who were the most rigid. The young people desperately need new service models, okay? You're talking about a situation where 70%, 50%, some percentage of our collective people are not represented at all. Can you imagine if you go to a healthcare center, you've got 70% of the people who have cancer can't get a doctor? That's what we got. They desperately need new practice models, whether they want them or not. They need to figure out how they're going to reach that 70%, because I don't think the government is ever going to fund legal aid enough to get those folks represented. And so we need a lot of flexibility, and we need a lot of alternatives, which are challenging, but the people most likely to adopt them are people who are sort of disgusted with the current or concerned about the current one, and the young. Okay, every time you look at a litigator and say, I'm right and you're wrong, it was all the self-identity stuff that Julie was talking about. They brought that up to me over and over and over again, and they said, these people aren't real lawyers. And I go, oh, yes, they are, and they're doing a different thing than you are. We live in part by rejecting the court system. Okay, we say the court system is terrible. Come to us to help solve your problems. You're better off doing self-determination. I agree with that in concept. You should be doing self-determination. But there are also people who really need to go to court. And we need to clearly say that over and over again, because the litigators seize on they distort it. I mean, they're really good at that stuff. And they take words out of context, and that was the stuff that kept getting quoted back to me over and over again.
Well, here's what I would like to kind of focus our discussion on. I think these are the kinds of issues and discussions that we need to be able to have. And we need to be able to have them very frankly. But what we run into is sort of what's the right metaphor, a whipsaw, a chainsaw or something, of defensiveness. And so the question really is, how do we put this stuff on the table where it really does perceive it to be attacking their own sense of who they are, their own identity? What is it that we need to do to put it on the table and to respond to what we're hearing in a way that we can really then have a discussion that's really about change? But I think all of us have an obligation to understand that we look at things through the lens of the practice we like, and therefore we are, no matter what it is, collaborative, mediation, litigation, surgery, that no matter what it is, we are more likely to see that the need is what we have to offer. So, Andy, you want to have a minute for final reflection where we go from here?
First, I want to thank everybody. A lot of for whoever, I'm sorry I didn't see you, whoever came back from the abuse you suffered in Los Angeles,
over here.
We appreciate that. We really do. But I also want to say, I think we are in the middle of what Julie's described accurately as a legal revolution. Also, the legal job market, at least in the U.S., is terrible. And how they're going to get jobs, and law schools are shrinking, and whole bunches of things are happening that are the process of change is very short, much shorter, more dramatic, and is going to continue much longer. And we really need help, because I think I'm a big fan of lawyers. I train them. I make my livings from teaching them. I think they do multifaceted things. And I want as much help as I can get in helping that profession both serve its traditional values of like they did this morning, representing the young girls who were raped in Kenya. That was fabulous. Okay, that's exactly what lawyers should be doing and well, versus, all right, let's fight about whether it's 2 more minutes to when you pick up your kid.
Two quick things I want to say. One is that the lady who left in Los Angeles talked about starting in a place of respect. And, and I think for myself, I feel like I have enormous respect for lawyers. The second point I want to make is that it seems to me that one of the things, and this comes from many of your comments, that we have to be able to do is to help people to be comfortable with being uncomfortable. And in a way, that was why we wanted to do this session, and not just to leave what happened last year kind of on the table. because this is going to be difficult. You know, you were very eloquent on the massive challenge that you face now in practice in trying to adjust to your clients' expectations. I totally hear you. I have so much I know what you're talking about. That's a huge challenge, and it is an uncomfortable place to be in, looking at so much change.
That I have to be providing stuff that's helpful to people. And challenging can be helpful, but you have to do it in the spirit of trying to be helpful. Thank you very, very much. We really appreciate this.